Welcome, everyone. I'm glad to be here with you to talk about one of the most important parts of financial planning to me, and that is leaving a legacy of financial strength. And how do you do that? Well, you do that through estate planning and through making sure that you have a will and some other really key documents that can be very important to your estate or your disability plan. I'm here today with Lori Ann Douglas, a good friend and estate planning attorney extraordinaire. Everything you want to know about estate plans, you ask this lady. Everything you want to know about wills, you ask this lady. And everything you want to know about planning for the what if, the unexpected, in terms of the legal ramifications, you ask this lady. I'm very interested in hearing what she has to say and the answers that she has to your questions. But let me tell you a personal story of why this area is so very important to me. You know, I wrote a book about couples and financial planning over 10 years ago. And in that book, I talked about how important I thought estate planning was. I was newly married. I didn't have any children yet, but yet my husband and I had decided that we want to have financial strength at some point. We weren't very strong at the time, but we wanted to have financial strength at some point, and we knew that we probably should put together an estate plan and a will. So we did, without children, but knowing that we wanted to have children. We named guardians. We made sure that we had designated certain people to execute the will, the executor of the plan. We also made sure that if something happened to us unexpected, we had someone who could make decisions for us. So my husband became my healthcare proxy and my durable power of attorney for medical and for financial needs, and I became his. And we named successors in case something happened to the two of us. Well, let's go to now 2016, September of 2016. And on my way to work, I was exercising. I was in an exercise studio. I felt the worst possible pain I could ever have experienced in my head. And I realize now that at that moment, I literally had a vessel in my brain that exploded. I had a ruptured brain aneurysm. I had a hemorrhagic stroke. And in the trying to fix that required several hospitals to go to, and it required me not being able to be conscious for some of that time. So who was making those decisions? Who was making those financial decisions? Who was making those medical decisions? I had pieces of paper that let people know who could make those decisions. That was part of the estate planning that I'd done more than 10 years before. So I'm here to tell you that even if you're still here, some of the documents that Lori and estate planning attorneys can help you get together, you may need when you least expect it. So Lori, thanks again. I'm so glad that you're here with me. And tell us just a little bit about how you got into estate planning and why this is such an important area for us to focus on.
Hi, Sharon. Thank you so much. And thank you to One United Bank for having us here to talk about this so important aspect of life for the African American community, especially. So Sharon and I have been speaking about the importance of estate planning, disability planning, wealth generation for years together. But I started in this area after I graduated law school many years ago in the 80s, actually. I first became a litigator. I was a litigator at a big firm, and then I went to the Manhattan District Attorney's Office. And when I was leaving the DA's office, I wanted to practice private practice. And I wanted to pick an area where I could help and work for Black people. Majority of my practice, I wanted to concentrate in the African American community. And I wanted to pick an area where I could make a difference and really provide some value. So it just so happened that my then husband was a life insurance salesman. So shortly after we got married, I started learning about life insurance and health insurance to help him in his business. And in learning about life insurance, I started thinking about, estate planning. And maybe this is an area where I could concentrate my practice. And so this was 1993. And I started some good friends of mine, they were having a baby. So they asked me to do the will. And then sadly, my best friend's grandmother passed. And so I got that estate. And I went to a continuing legal education class about estate planning. And there must have been 250 or 300 lawyers, and there was not one lawyer of color at all in this class.
Wow.
And I thought to myself, I know a lot of Black people are going to die, and I could build a practice in this area and add value. And that's how I got started. And it really has been so rewarding because our community really has to start planning in larger numbers so that we can hold on to the wealth that we are finally getting to be a part of in America. I always say it takes a long time to go from being the assets to having the assets and having enough time to plan for those assets. And so we are now at a generation, a few generations out of slavery, where we have some assets and we really could become a wealthy community if we take the time to focus on putting the documents in place that you need when you need them in an area where you don't know when you'll need them. But everybody is going to need an estate plan. So it's putting the documents in place early. And so that if you have a medical emergency, such as yourself, or if you have a long-term disability, such as Alzheimer's, I have lots of clients who, as soon as they get a diagnosis, they do that planning and put those people in place because you're going to need somebody to make decisions for you if you have such a long-term disease. And so it's really important to do this early. And once you've gotten your plan in effect, live your life to the fullest, but know that if something happens, you and your family members are protected.
Absolutely. Laura, as you said, we've talked about this quite a bit. I talk about it all the time on CNBC as CNBC Senior Personal Finance Correspondent. But having the conversations about money and then making sure that what you do with your money is legally protected is not something that many of us do. How do you start that conversation?
Well, for me, the way I start it most of the time is in an educational forum like this, right? I spend lots of time speaking in churches and for sororities, fraternities, places where our community meets to educate people. So that's really the first step is people, having some interest. Why should I do this? Learn a little bit about it. And then the other place, the way that people come to estate planners is through an advisor that someone already has that comes in contact with their money. So for many people, I get referrals through financial advisors, life insurance salespeople, accountants, mortgage brokers, realtors, people that come involved with people when they're making, big purchases, buying their first home, or if their CPA starts to see, 1099s for stock or whatever, then those people really say, hey, you need to go see somebody to help you get your affairs in order. So for most people, if you don't come through a financial advisor and you don't educate yourself, the reason you do it is some tragedy has occurred in your family. And now you recognize, wait, we have to do this before we lose, our grandmother's house like our cousins did, or before this money cheats back to the state because we didn't claim these funds or whatever it is. That's often the other way that people really think about it, unfortunately. Is that something bad has happened to somebody else, and so now they do their planning, or celebrity passes, something like that. But that's how to start the conversation. You just have to start it. You have to talk. You just have to
start it. There are a lot of people that could potentially be involved in the planning of this. But let's start with the basics of what you need in an estate plan. What are some of the key documents, and who are some of the key people?
Well, in every estate plan, I always say estate planning is kind of a misnomer in that it makes it sound like you need to have a whole lot of money or a whole lot of property to do it. You just need to be 18 years of age. That's really it. Because once you're 18, then you can own assets. And or if you're a parent, you have to start planning as soon as you become a parent and as soon as you acquire anything, as soon as you start a job. So what are the first steps in a plan? Often, the first steps are making sure your beneficiary designations are correct at work. Making sure if you have a bank account and you can have a pay on death on the account, you can put that on there. But starting as you start out in life, making sure your basic things, and then everyone needs to have disability planning documents as well as estate planning documents. And those disability documents you already touched on. Everyone should have a healthcare proxy, and a financial power of attorney. And those documents appoint someone to make your medical or financial decisions when you cannot make them. And the reason it's so important for young people to do this is because once you're 18, your parents are not entitled to any of your medical or financial information. And so for many, especially college students, if you go away to college and you go to the hospital, your parents are just going to receive a call. Hey, she's in the hospital, but they're not going to tell you anything. When my son went to college on his 18th birthday, the first thing he did was he signed a healthcare proxy naming me agent and a financial power of attorney. And I sent those up to the college. He's graduated now. We didn't have to use them, but they were there. So those are the things. You need your medical directives, your financial directives, and then everyone should have a basic will depending on, your circumstance. And from that will, if you have a lot of real estate, a lot of financial assets, life insurance, then you do more complex planning using trusts and the like. But that depends on your personal circumstance. And the other reason it's so important to have a will is the only legal document where you can nominate guardians for minor children. So a baptismal certificate or your family's understanding or whatever, that is not going to be sufficient. If something happens to the parent's nomination of guardian takes precedence to the court. And so it's really important to have a will for that, even if you're a young person. Not much money, but precious cargo in those babies. So you need to have a basic will. And that would be what we consider a basic plan. A healthcare proxy, a living will, a financial power of attorney. We often do nominations of guardianship, just in case you end up in the court system, and then will or revocable trust-based planning.
Gotcha. You started off by talking about beneficiary designations. And I think it's important for people to understand that, because if you're just starting work or you have a company retirement plan or something that you're contributing to, and you don't have a will, and perhaps you've had life changes, you're not still with the same person that you were with when you had the job, but that person's name is on your 401k plan or your 403b plan, that could be a problem. If the beneficiary designation says that person, that's the person that gets the money, right?
That is true. And for most people, it's not so much a partner or a spouse. In many states, just a divorce legally cuts off beneficiary designations, bequests and wills. In New York State, it cuts off, nominations of fiduciary. And so you don't necessarily have to change that if you get a divorce. You should, of course. But the biggest one is when people start jobs, they're often single. And so they put their parents, everybody puts their mother down as a beneficiary. And then they get married. And then they have children, all these things. They don't leave the job and they never change that beneficiary designation. Well, I can tell you, it doesn't happen often. During COVID, we've seen, so many young people die. Just unusual things happened last year. But the few times that I have had an experience where a young person dies with their mother still on their, beneficiary designation, if they're married, they have children, it doesn't matter. I have yet for a mother to give that money to the family. The mother always says, no, he loved me. He meant for me to have it. And so it's really important to update those things. It's really important to make sure, if you do get married and, you don't have a prenup, you have your spouse gets certain rights immediately in ERISA-based retirement plans. They have to waive their interest in it or else they get it. So you have to really not only make sure you pay attention to those beneficiary designations in case they need to change, but make sure they properly coordinate, because I've also seen it where, a parent has two children and she leaves, the house to one child and the life insurance to the other one, thinking that they're going to all work it out together. And what happens is the one that got the life insurance runs off with the money and leaves the one with the house holding the bag and the mortgage and the expenses and doesn't have any money as liquidity. So you have to make sure those things coordinate so that your plan is effective.
Absolutely. So, Lori, how do you decide who should have these different roles? Who should be the beneficiary, or who should be the guardian, or who should be the executor of my estate or my will? the healthcare proxy, the financial power of attorney. These are very important roles. They require real people that are going to have some skills and be able to do what you want them to do. How do you pick the people, and how do you have the conversation with them about what you want them to do?
Well, in terms of picking your fiduciaries, to be perfectly honest, the most important thing is to pick someone who will do the job, who will follow through and will honestly, efficiently, administer your estate, or will make decisions for you that are good for you as the power of attorney. And so in choosing the people, most people choose their own family if they have family or friends who can do these jobs. If they don't, you can always pick a financial advisor, a lawyer. You can even have a corporate trustee if necessary. But for most of us, people have family and friends. And what I tell them is that, pick the people that follow through with things. If your brother starts projects and doesn't finish them, don't pick him to administer your estate, but pick somebody who follows through, who will hire proper counsel, who will hire an accountant, who will hire a financial advisor to invest the funds if you have trust, those kind of things. And that's honest, because you want to make sure that you pick somebody that's not going to misuse your assets or misuse your money. I often tell people, don't pick somebody who has their own money problems. Don't pick somebody who you think their spouse is over, will be over and involved in it. Will try to get them to abuse the trust. Don't, pick loving people to be physical guardians for your children, but you can separate the love and the money. Pick your financially responsible people for those decisions. So that's really how. And when I do planning, most, every meeting is a minimum of 2 hours. And the reason it is because I want to talk to my clients about their people. They have to tell me honestly about, let me know if your child has a substance abuse or an alcohol problem, or is a spendthrift, or has filed bankruptcy, or all those things. Tell me now, so I don't, put them in charge of your estate, or so we leave money in trust as opposed to outright, so we can plan. But that's how you choose your people. There's one group of people are the fiduciaries, who are going to make the decisions, the executors, the trustee, the healthcare proxy, the power of attorney. And the other is who benefits. Those people are, who are the people that you want to leave your legacy to? Are they charities? Are they individuals? Are they, young people you want to help them with education? So those decisions are personal, who you want to leave it to. And then how you leave it, the estate planning attorney helps you to create the plan. And then we choose people that are going to, effectively administer your estate. Remember, your executor's job is to hire the lawyer and the CPA and the investment banker, and to do all the things to help you to collect the assets, pay the debts, pay the taxes, all those things. That's that person's role, but they hire people to help assist them to do it.
Absolutely. And I think having that conversation with family members or friends, some of us don't like to talk about money. I know I grew up we don't talk about that. Mm-hmm. It's your money, and it's not, it's not correct to share your business like that. But you do when it comes time for something like this, you need to know their business. You need to know how they're handling their finances, how they make decisions, how they handle stressful situations. And I will say, in my case, having to go through a medical emergency, I got to see how the people around me reacted. And I must say there were parts of our estate plan that we changed after that happened, because we got to see how people reacted in situations and who they contacted or didn't, or what happened. And it was very telling. So unfortunately, I've had a run through. So everything Lori is telling you, as I'm telling you, everything she's telling you is absolutely correct. In this case, I actually went through it a little bit. So I'm telling you that for sure is absolutely correct.
Yeah. Lori, and one thing, Sharon, I was just going to say that one thing you were saying is you had the run through, but that's one of the reasons why it's so important to discuss it, because if you don't usually have the run through, and if you don't say to somebody, I want you to be my healthcare proxy, and they don't know, they might not want to do it. I have had that happen where somebody is in a state where they need somebody to make their and the family member says, I don't want to do that. I didn't sign up for this. I don't have enough time, or I'm too emotional, or whatever it is. So that's why you really have to make sure the people are part of it and they agree to be part of it, so that, you don't have a crisis and then people don't want to make the decisions.
Lori, you are so right. I'm thinking back to one of my dear friends when she was single. She picked a coworker to be her healthcare proxy power of attorney. We've been friends since we were in nursery school. She's the godmother of my children. I'm thinking, you picked who? You've known her 5 minutes. And she said, you would not pull the plug. You would not do what I want in my living will. I know you get too emotional. And don't you know, on her wedding day, I was bawling. I was happy for her, but I was so emotional, and she knew. She knew. So you also can't get offended when a family member or friend does not pick you. It's not personal, but it is. It actually is.
Right.
It's very personal.
Right.
And so you have to realize what your strengths and limitations are and allow that person to pick the person that they want for those very, very critical decisions and critical times in their lives. So you are, once again, so on point. So on point. I want to get to these questions because so many people have been eager to hear what you have to say to their pressing questions about wills and estate plans. And one of them says, if I do a will, am I going to die immediately?
You know what?
Is it a bad omen?
Absolutely not. I mean, in my experience, I've now been doing this for close to 30 years, and it's kind of Murphy's Law on steroids in this practice area. When you have those documents, you are living proof. When you have those documents in your place, you may need them, but it doesn't kill you. If you don't have those documents in place, that's when you have a problem. If you didn't have the healthcare proxy and your family had to go to court to establish guardianship and the time and the cost and whatever, they couldn't be making those decisions for you. Or people, most people die without an estate plan. And the reality is every single estate administration is more costly, more time consuming, and always causes more unrest amongst the family members when there is no plan. It's just across the board. There are always more costs, always more time. It's just, there's never an experience where if you die without a plan, it's easier than if you died with a plan.
Yeah. No, I wanted to ask you about cost. You brought up cost, and I think that's another big reason why people say, I don't have hardly any money, and I definitely don't have money to hire somebody to do my estate plan. How do you make it cost effective? I mean, they should hire you, of course, but can you do it on your own? Can you do it online? Should you? What do you think?
Well, there are parts that people can do themselves. I will not ever advise anyone to do their own will or trust because they're just too complex. And we are starting to see a lot of badly drafted wills. We're starting to have a lot of litigation based on DIY will kits. So, in terms of cost, it's going to vary depending on where you are in the country. It's going to vary depending on the expertise of the attorney. But for a basic will, it's nominal, the cost for this planning compared to what you're going to save your family on your passing, especially if you own, real estate, if you have money in the bank, if you have life insurance, if you have retirement funds. There are a lot of assets there. And so the planning is, the cost is nominal, truly, compared to the benefits of the planning. But in terms of medical and disability planning for financial directives, everyone can do that themselves. Almost every state, I think every state, on your Department of State website, your public health website, title companies have financial powers of attorney. So you can go online and you can get the healthcare proxy, the living will, the financial power of attorney for your particular state. That's one thing about planning. It's very state specific. And so you can go online, you can complete those forms, you can pick your own healthcare proxy, have them witness or notarize whatever your state requires. But those forms are statutory in nature, pretty much says in there what the state allows, so you don't have to change those too much. So go ahead, everybody should get those forms today. You could fill them out and have those in effect by, the end of the day today, a healthcare proxy, a living will, and a financial power of attorney. For wills, you go see a lawyer.
Yeah, Lori, in covering this for CNBC, during this pandemic, I was very interested in the fact that it wasn't just attorneys and financial advisors that were saying, go online, get that medical information, get the financial power of attorney, the healthcare proxy, the living will. It was doctors. It was doctors saying, we want you to come into our hospital having that living will, having a healthcare proxy, because if you can't speak, if you can't breathe, if you're having trouble breathing and we want to do what you want us to do. So they have no financial, they're not getting any financial, reward from actually having you have these documents, but they're having the reward of knowing that they're honoring your wishes. So I've heard that from a lot of folks, that it's very important to have those documents, and you can get them online very easily. So
Yeah.
it's everyone should do today.
Yes, I was going to say, during the pandemic, especially the other reason the medical profession is, they're just as hot and bothered about these documents as we are now, is because the courts closed in a lot of states. I mean, in New York, the courts shut down the doors completely for months. And so that meant if there is a medical, crisis where somebody would normally go to a judge to decide that, there were no judges. So there was no one available. So COVID created circumstances that we've never seen before. But for those people who have the documents in place, right, you're there. But many people went to the hospital. They were unconscious. Their family members can't go in to see them. You can't complete the documents because they're not allowing you in. So it was so important. This 2020 really, it was like no other year ever for estate planning. And I will say, it was the first year that in my practice that they were beating our doors down on the planning side as much as on the administration side. People have really started doing their planning in record numbers.
Yes, they're starting to look ahead. Well, that's why we have all these questions for you. Here's one. Someone is asking, how can I approach my parents and my grandparents about them having a will? So that's a good one. Sometimes, again, if you grew up in a family where you don't really talk about money and what you have, and how do you start that conversation with your parents or your grandparents?
Yeah, I think the way to start it for most people is, you have to be honest with your parents about, as they're aging, that you need to know in order to help them. But then in order to be sure that there's an ease of administration, especially if you have more than one child. Right. A lot of times people contact me, oh, it's just me and my mom and she wants to do a will. Great. She should do a will. But if she didn't, everything would go to that one child by operation of law. But if you have more than one child and you only have one house, maybe one child lives in the house and the others don't, then there should be a conversation. Well, what's going to happen when you pass? We're not going to pay the mortgage for our brother or sister. And so I think by starting the conversation, as with your parents, what if you get sick? What if you have a stroke? And those kinds of things, parents will, they don't want to make it more burdensome for their children. So if you can start the conversation, well, what if, and take it in steps. First, what if you, became ill? How would we help you to pay your bills? And then what happens when you pass? How are we going to, pass this estate and do it in a way that, benefits the family? We put it in trust, or we hold it, because obviously, if you have an estate and you just distribute it out to however many children in equal shares, that money doesn't grow. The legacy doesn't grow. It's just going to end. And so by having that conversation, where do we start? I think that's the way it starts, with parents and grandparents. And many of our clients come to us first through their adult child, right? The adult child is the one that calls and says, my mom needs a will. And then I talk to the mom in private, and then we proceed, as long as I know that mom's competent. But that's usually how older people get to us. It's their adult children that say, hey, don't leave me in a lurch. And especially if kids don't get along, or some are very successful, some might not be. It's really important for somebody to say, Mom, let's make sure you're involved. And we do this because for many families, what keeps the kids in line is mom. And so when mom passes, Anything goes if you don't have a plan.
Lori, can it help if a family member does their estate plan first to then bring in parents or grandparents by saying, I did this, mom, dad, grandma, maybe would you like to try something like this, or this is what it takes? Does that ever happen that you have an adult child do their estate plan first and then bring in a parent?
It doesn't happen often that way, but it would be helpful if it did. But what normally happens is the adult child says, "Mom, it's time," and then through the parents' planning, the adult child says, "Oh, I better do mine also." But it certainly would be helpful if people in there, like I say, most people start. First of all, most people don't do their estate planning. That's the first problem. But for those that do, they start it late. So people are, often coming to us, well past, 60, 70, 80. They're saying, oh, I think it's time. Well, it was really time when you were 30 and 40, 50. So if that age group came, if we really had the planning started by the younger people, and then they would bring in their parents, that would be the best way for the planning to work. But most people don't think about it when they're young unless there's something specific. And that's unfortunate, especially now, because young people have a lot of assets now, and digital assets are a whole big thing. And people not recognizing there's value in those, TikTok videos, and there could be real value in those. And so if you don't have, copyrights, royalties, all of those things, you have to plan for too. Your digital assets are something to plan for. And so, you need to start it early, but that would be great. I wish, let's try to get
more people to do it that way, right? So you talk about a lot of people don't do it, and those who have a lot of assets, even celebrities, movie stars, musicians. This person is asking, why didn't Aretha Franklin, Prince, Chadwick Boseman have a will if it's so important? I mean, that was a shocker to me. We've definitely talked about these situations in the past, Lori.
Right.
Why didn't they? And what is the issue here?
I think they didn't for the same reason most people don't. One, most people all think they have time. Those are three people that all thought they had time. Aretha had some handwritten wills, so it wasn't something she wasn't thinking about, but they did find handwritten wills. I haven't followed it as to whether the court's going to recognize those wills, but she did. Prince, I don't understand why he didn't, especially when he got his music back. They should have just put that in trust right then, and so it would never have been an issue. And Chadwick, it seems like he was sick, and that's what was, taking a lot of his time. But I always say, Chadwick Boseman didn't have absolutely no estate plan. He created an estate plan because he married his wife. And so that was his way of creating an estate plan. Had he died single with no children, his estate would have gone in equal shares to his parents. But by marrying his wife with no children, his whole estate goes to her. So he did create an estate plan in the marriage, but he didn't have a will. Why they don't have it, I have no idea. I represent quite a few celebrities, and I think almost all of them, the reason they came to me is because another celebrity had passed. And that was the thing that made them think I better do it
now. Yeah. I think it's true for a lot of people, celebrity or not. Someone passes and you realize that it can happen at any time. You just never know. You just never know. But still, there are other people who say, I don't have a lot of assets. I'm not Chadwick Boseman. I'm not Prince. I'm not Aretha. So why do I need to have a will?
You need to have one because whether you have a lot of assets or not, those assets are not dying with you. So when you pass, your assets are going to be here. If it's a bank account, whether it's $5,000 or $500,000, if you don't have a pay on death or a beneficiary or in trust for, you have to go to court in order to get the money out of that account. And every state's process is different, some more complicated than others. There are requirements as to who can become the fiduciary of an estate. People have no estate planning, and you pass, you might have children that don't qualify. You might have, one child. I had a client who one child was a felon, didn't qualify to be the fiduciary. The other child had filed bankruptcy, didn't qualify to be a fiduciary. So if she had a will where she picked her sister, the lady it would have been a much easier administration. So whether you have a little bit, whether if you just own your car, if you have, your personal property, all of those things, in order for them to get to whoever they're going to, there has to be a process. And if you don't pick the process, the state's law just governs the process. I mean, would most single people with nieces and nephews leave their estate to their nieces and nephews. If you don't have a plan, there is no way your estate will ever get to your nieces and nephews if your parents are living and your siblings are living. It's impossible. So you have to have a plan. The state's plan probably does not work for most people.
Got it. Got it. Here's a good one from someone who says, if someone is going to inherit my assets, will they inherit my debt as well?
Yes, because they don't inherit the assets until the end of the estate administration. So when a person dies, the fiduciary is appointed, and that person's job is to, one, marshal the assets of the decedent, pay the decedent's debts in the proper order. And the first people to get paid are, the funeral director is the first person. You have administration expenses, but then taxes. So when a person dies, if you haven't filed, the fiduciary is responsible for the final income tax return for the year of the death. But if somebody hasn't filed for the previous years, the fiduciary becomes responsible for those. In states where there are inheritance taxes, estate taxes, you are responsible for those. If there's real property tax due, responsible for those. Then you get to the debts of the decedent, your credit card bills, your medical bills, whatever are your debts. Then, after all those debts have been paid, the attorneys have been paid, the court has been paid, everybody's paid, what is left is what is inherited. So it is possible that, and I've had many illiquid estates, the debt outweighed the assets. And what happens? You pay the debt in order until you run out of money. And that's it. There is no inheritance. So if your mom has $50,000 in credit card debt and she owns a home, the creditors could come after that home to get their money. So, that's
very good. That's a very good point. I do think people, Lori, are concerned about that. And I've had friends ask me, do you know, am I going to have to pay off? My mom just passed away. Do you think I have to pay her credit card debt? And, again, that's someone, no will, no estate plan, no thought through. But you knew your mom wasn't great with credit card debt, right? So
right. And if she has any assets, right. And if you have any assets, they can, certain ones, maybe not a retirement plan, but a house, certainly. Like people all the time say, well, my mother didn't have anything but a house. I was like, well, that's probably worth several $100,000. And so we got these debts over here. You're going to have to sell it. And another thing that happens a lot of people, especially with elderly parents, is, reverse mortgages. Yes. Reverse mortgages have their benefits to the homeowner because they need money to live and give them income. But those reverse mortgages really, they come due like almost immediately when the homeowner dies. And so then the children often have to sell the house right away to pay back that reverse mortgage. And the children often don't understand that's how that works. So when they contact me, they're like, well, we want to keep the house. And I'm like, well, you got to pay off this $300,000 reverse mortgage. Do you have some way to do that? Or else, you're probably going to have to sell.
Yeah. Yeah. You talked a lot about how costly it can be if you don't have a will to go through the court system. But can you explain exactly what is probate?
So what probate is, it's the process of authenticating a will. So probate is the process when you go to the court when you have a will. If a person dies without a will, that's called administration. You die intestate without a will. And still, you have to go to the court, but it's a different process because now the estate is administered pursuant to the state statutes with no will, as opposed to pursuant to the will's terms. So when people talk about avoiding probate, the only way you can avoid probate is if you structure your plan using vehicles that don't require you to probate a will. So if you take a revocable trust and you put all your assets in a trust while you're alive, then you can administer your assets through that trust on death without having to go to court. So then you don't need the will. But if you forget an asset, then you still need the will. But that's what probate is. It's the process of authenticating a will, this piece of paper, and saying, here, judge, offer it to probate. The judge says, yes, it meets the requirements for execution, attestation. The person was, competent. They weren't under undue influence, all the requirements for a will. And then the court says yes, and then you get appointed. That I often meet people who think that if someone writes a will and nominates the executor, I often meet people that think that that is sufficient. That, the person dies and the nominated executor just starts walking around giving orders. But that's just a nomination. You have to go to the court in the county where the decedent, the person who made the will, lives, and have the court authenticate it and then appoint the fiduciary.
If the courts are involved with the will in any way, does the will become public?
Oh, yes, it's a public document. That's the other reason why revocable trust-based planning is preferred by certain people, because a will it's not only is it a public record, but now it's really public record because everything's going to be online. And so that if you have a revocable trust and you don't have to probate a will, then that is administered privately. So there, whether it's celebrities or important people in the community, the minister or somebody who doesn't want people to know their business, revocable trust-based planning is a very good alternative, because then you don't have to have the public record of the will. And the other thing is with wills, you have to the state requires you to find the next of kin often. So there are plenty of people, they leave a will, they leave everything to their friends because they're not close to their siblings, not knowing that when they die, you're going to have to find those siblings. So if you have a revocable trust, again, it's private. You wouldn't have to go locate the siblings to let them know they've been disinherited. You could just administer it through the trust.
Can you give me the basics on a revocable trust? Like what are the key points of it? You mentioned some things that differ from a will, but
Right.
What are the key points of it, and why should one set one up, and how much will it cost if I do?
Right. Well, again, the cost is going to vary depending on state by state, practitioner. There's no difference. If I do your planning, we charge the same for a revocable trust with a pour over will as we do for a last will and testament with trust in it. But what a revocable trust is, a will substitute. So it's a document that's created by a lawyer, where you, Sharon, if it was your trust, you would be the grantor of the trust, the person creating it. You would fund it with your assets. You would be the trustee. So you would take your bank account, your house, your life insurance, whatever it is, and you would put it in this trust and you would manage it just the way you do during life. But if you became disabled, we have disability trustees built in, and we have a disability trust. So now those people step in, and now they take care of you with your assets. And then on your death, you administer the trust without having to go to the court, because all of your assets were already inside of it. If you forget an asset, let's say you had a bank account from years ago and you had forgotten all about it, and now as your trustee is administering your estate, they see something, oh, what about that? You would now take what's called a pour over will. And it's just a short will that says, if we have to probate this will, probate it, and then take the assets and pour them into the trust and administer pursuant to the trust terms. So that's really the difference. The revocable trust allows you or your loved ones really to skip over the court system entirely, as long as it's fully funded at your death.
Does it matter state to state? Do you have to be very particular, I should say, state to state, in terms of the will, in terms of the revocable trust? You talked about state specific for some of the medical and financial power of attorney documents, but what about for a will or revocable trust?
For everything. This field is very state specific. There are obviously federal laws, especially in terms of taxation, that come into play, but it's very state specific. So for example, New York, right, has income tax and its own estate tax. Florida, no income tax, no estate tax. That's why you hear people, make their money in New York, but it dies in Florida because people move down there to establish their domicile to avoid the income tax and the estate tax that you might have to pay here in New York. And in New York, while the estate tax exemption is pretty high, it's over $5 million. The reality in New York, a lot of people could have estates that large easily just from owning a home. I can't tell you how many clients I have in Brooklyn that bought their brownstone for, $25,000 in the 60s. And now their children are inheriting these brownstones. They're $3 million. And so right away, you could have different taxation issues based on state, but then there are also different laws in testacy. Maybe there's an elective share statute. That's a statute that does not allow the disinheritance entirely of a spouse. New York is a state that has it. Some states don't. So if you try to disinherit your spouse in New York, you might not be able to, but you could move someplace else where you can, and then you could change your will. So you definitely want to know, the state laws as well as the federal laws for estate planning, as well as, for the medical, all planning.
Okay, Lori, I don't know how anybody could want an estate planning attorney other than you, but if they can't find you, if they can't hire you, and they want to try to do it on their own, does LegalZoom, Rocket Lawyer, online this or that make sense? And if so, what are the things you need to look out for? What are the potential pitfalls if you do it online, or what are the pros for doing it online?
Well, again, I am not a proponent of DIY will kits because wills are just too complicated. And they're people think, oh, they're easy to write a basic will, but if you do something wrong, you really leave your estate open for a will contest. So it has to be executed properly. It has to have the right amount of witnesses. It has to be, whether it has to be notarized, whether it needs a self-proving affidavit. And then not only does it have to be written properly, but if you don't understand what you're doing and the articles and the provisions, you can cause more problems than you recognize. So, for example, I just met with a married couple that had created their own wills on one of the software programs. And they had created trust. When, one person dies, there was a trust created for the survivor. Well, that's all well and good, but if you have a trust for a surviving spouse and that person is the sole trustee, it's like there's no trust. There's no creditor protection. If I'm the only trustee of my trust, I can do whatever I want with it. So what they were trying to achieve, which was some creditor protection and help for the spouse and to create generational wealth to stay entrusted, it wasn't going to happen because they didn't set it up properly because they didn't know better. So that's why I'm really against the DIY will kits. Like I said, medical and financial directives, definitely do them yourself. But for the will, and you don't have to go to me, nor do you have to go to an attorney that only concentrates their practice or, handles high net worth clients. You can go to, an attorney who does wills and knows enough to be able to work through with you your beneficiary designations, to make sure you remember to check everything at work, to make sure you coordinate your personal property, to make sure that if you have any collectibles, people don't recognize you got, a record collection could really have some value. Barbie dolls could really have some value. Artwork has value. So if you don't know enough to even talk to somebody about, well, how do I address these things in my will, it can really cause complicated problems. So see a lawyer for the will, but you can do the medical and financial directives yourself.
Great advice. Great advice. I have one more question for you, actually a couple more, but this one is one of my favorites. How do I manage my family's expectations if I do a will? For instance, stepchildren, former spouses. How do I avoid a hot mess?
Well, first of all, if you're going to do it in a will, one way to avoid it for you is not to tell anybody because you'll be dead. So that might not be the best solution, but for many clients, that's the one they take. They tell us and then they don't discuss it with their family. But the way you avoid the hot mess is to have the plan, because the lawyer will be able to tell you what different people's rights and obligations are. So for example, exes are nothing. They're out. You know, if you want to leave something to your ex, unless you specifically say, I'm leaving this to my ex-wife, even though I know she's my ex-wife, most states will cut off the bequest with the divorce. So you can't really leave to your exes. You know, if you have minor children with, exes, that causes a problem because that ex can come in and get status in your estate through the child, but they can't collect themselves. Stepchildren, step parents, you have to have a plan. They are not recognized in the law at all. I had a client who has, stepdaughters that she considers her daughters, and she wanted to leave her estate plan really to her grandchildren, her stepdaughters' children. And she was just taking forever. And she was like, oh, no, it's just easy. I'll get to you, Lori. And finally, I said, listen, you can get to me or not, but I'm telling you right now, if you die, there is no way at all under the law those children will ever get a dime because they are not your grandchildren. She was like, that lady, that day, she focused. I was like, they'll just never get it. Your sister, who you don't talk to, is going to take your estate. So those are the reasons why you have to have the plan to provide for the people, your charitable bequests. A lot of people like to leave something to their church. A lot of people have friends. A lot of people want to leave tangible personal property to different family members. If you don't have a plan, a will, something, it will never, ever get to those people. That's plain and simple. And when we do our planning, because we also litigate, we really go above and beyond to try to create wills that are bulletproof. And how we draft them and what we know. When people want to disinherit family members, you got to tell me all your business as to why you're disinheriting a family member. If you just say don't put her in, that's not enough, because I'm going to need to know later on, if I get deposed in a contest, why did she do this? This is why it made sense. And so that's why the lawyer really can help you to avoid the hot mess. But otherwise, and the other one, oh my gosh, the other one is, married people who have been separated for 100 million years, and people got new boyfriends and girlfriends, but they never got a divorce. Doesn't matter that you never got a divorce. Your spouse comes in and takes. So it's all kinds of problems occur if you don't really have a plan.
It's not just avoiding a hot mess, because those are certainly hot mess situations, and we all know them, know people have gone through them, may have gone through them ourselves. But the other major reason why Lori and I are so passionate about this topic is that it is a way to create wealth. It is a way to build wealth and create generational wealth. And Lori, if that is one of the questions also from one of the attendees, how do we use the will to create generational wealth? Why is that so important?
Well, the best way to create generational wealth is the use of trusts. And you can put those trusts inside the will, or you can have standalone trusts. But I'll tell you, my background out of big law, I was at a firm where the head of that trust of the Estates Department, world renowned, and he is all trust all the time. So I come from a background about trust, and that's really how you create generational wealth, because you keep the wealth, you keep it in a contained, you put people over it to oversee the growth, you can invest it, you can keep it for generations and generations, and then you can give creditor protection to your beneficiaries. You can build in protections in case somebody's disabled, in case somebody becomes disabled, in case somebody needs a special needs trust, all of those things. And those are the things that really allow you to create generational wealth. The will helps just in that it'll be cheaper to administer that person's estate. That will leave you more wealth. But if you really also do trust-based planning, that allows you to create wealth and transfer it from generation to generation.
And you don't have to be a millionaire today to create a trust, right? I mean, this is a way that we're trying to anticipate that we're going to build wealth and that we want future generations to do it, right?
Correct. And that's why we're doing a lot of revocable trust-based planning, because it's a trust that I create for myself. You create it for yourself for during your life. And then if you die, it's just all there to be administered. And so then By also doing that, you can bring in your trustee. So I have lots of clients who do revocable trust where their adult children are their disability or death trustees. Well, we bring them in now to explain to them, here are the assets, it's in trust. So that way, if something happens, they know what to do and they already are part of the process. So that's however you structure it, you can create the trust now, whether you have money or not, and then you fund it, and as you grow and as you create more money and create more wealth, then you just kind of branch out from there, create other trusts that will fulfill the needs as your estate grows.
Absolutely. So a couple of things that I think that people who are watching have been told now that they need to do right away. One is make sure that you get the documents that you can do on your own, get access to them, fill those out, and make sure you have a healthcare proxy, a living will, a financial power of attorney. The next thing you want to do is find someone, an attorney who you can talk to, and someone that you trust to tell all your business, because you're going to have to share a lot, to make sure that person can create a will for you or a revocable trust or some types of documents that will make sure that your assets and your wishes go to who you want. And if you have small children, make sure you have the guardians for those children so that they are taken care of. Those are your greatest assets in life, right? So you want to make sure you have someone to take care of those children. And you also want to make sure that you have conversations with the loved ones around you, those that you trust, about where you are financially and where you want to be. I think Lori talked a lot about the importance of making sure that you have an idea of where you want to end up, because that helps the attorney, that helps you, that helps your family know what needs to happen now while you're still here to make sure that you are able to achieve what you want when you're no longer here. That is how we build generational wealth as a community. Continue to follow Lori Ann Douglas on all social media. Find out what she's writing about, what she's talking about. As she said, she speaks frequently all over the country. You want to know the latest on what's happening, but the bottom line is get a will. Get it done. Get your estate planning documents done right now. Lori Ann Douglas, my friend, thank you so much. Always a pleasure to talk to you. We could talk about this for hours, but I know people have other things to do today. So we gave you your 3 or 4 points you need to get on right now. And before you close your computer, make sure you've done those things. Thank you, Lori. Take care, everybody.